In this presentation, we'll be looking at criminal investigatory search warrants that can be found in Chapter 4 in your book. Okay, search warrants is the law governing search warrants is based upon the guarantees in the Fourth Amendment to the U.S. Constitution. It guarantees you the right against unreasonable search and seizure, and it says that no warrant shall be issued but upon probable cause. Key word here is probable cause, supported by an oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So those are some key points. If you get an arrest warrant or a search warrant, you have to describe the place to be searched, the persons or things to be seized, and a seizure of a person is an arrest. Okay, exactly what is a search warrant? Well, it's an order that is in writing. It is issued by a proper judicial authority, a judge or magistrate, justice of the peace, whatever the case may be. It's in the name of the people, the name of the state of Texas, here in Texas, and it directs and commands a law enforcement officer to search for certain items in a particular area. The commanding officer is to bring the property before the judicial authority named in the warrant, and it's not necessarily physically bringing the property in. It's usually done as a return where you just give an inventory of the property. I've never brought the blood I got from a suspect back to the judge to show him the blood, but you do bring a return on the search warrant. In Texas, the search warrants are defined in 1801 of the Code of Criminal Procedures. It says a search warrant is a written order issued by a magistrate and directed to a peace officer, commanding him to search for any property or things, to seize the same and bring it before such magistrate, or commanding him to search for and photograph a child and deliver to the magistrate any of the film exposed pursuant to the order. Of course, nowadays we don't really use film anymore. It's going to be digital images, but the law hasn't been updated or modernized. Okay, applying for a search warrant, you have to have an affidavit that you're going to give to the judge that outlines your probable cause. It describes the place to be searched and describes the items to be seized. So you have to be pretty specific about what you're looking for and what the probable cause is that makes you believe that the judge should issue you a warrant. Who may issue a warrant? The issuing magistrate for a search warrant should be a neutral party, so they shouldn't have a stake in it. They should be detached and capable of determining whether probable cause exists for the requested search. In Texas, a judge of a municipal court of record who is a licensed attorney may issue a search warrant. There are not too many municipal judges that are courts of record. I believe Pearland is, which is very unique, and I know that Houston is. But other than that, most municipal judges are not going to be able to issue a search warrant. Second, a judge of a county court who is an attorney licensed by the state. 3, a judge of a statutory court, district court, or the Court of Criminal Appeals, or the Supreme Court may all issue a search warrant. Grounds for issuing a search warrant: the magistrate must have probable cause to believe that items subject to seizure or in a particular place or on a particular person at the time of the issuance of the warrant. The affidavit tries to establish probable cause in an affidavit. That's the affiant, and the affiant is the officer who is actually writing the search warrant and describing what evidence he has. Warrants must describe with particularity the places to be searched and the person or things to be seized, and this comes directly from the U.S. Constitution, or the Bill of Rights. Now back to Texas law. A sworn affidavit setting forth sufficient facts to satisfy the issuing magistrate that probable cause does exist, in fact exist for its existence, that specifies the offense to be committed, and that specifically describes the property or items that are to be searched for and seized, constitute evidence of that offense, or evidence that a particular person committed the offense, and 3, that the property or item constituting evidence to be seized, searched for, or seized or located at a particular person, place, or thing to be searched. Except as provided in 18.011, the affidavit is public information if executed, and 18.11 is, it allows for them to be sealed for a certain period of time for investigatory reasons. But normally in Texas, a search warrant is public. The defense is going to get a copy of it through discovery. So whatever you put in it, the public's going to be able to see it. We often kind of limit some information in a search warrant as long as we've got enough information to establish probable cause. You don't necessarily need to give all the information in the search warrant that you have in the case, because sometimes you'll inadvertently identify confidential informants or release evidence that you want to say secret for the sake of verifying statements and confessions later on. Different types of items that are subject to seizure include evidence of the crime. Could be the recovered stolen property, recovered stolen items, the drugs or evidence of the crime. Photographs can be evidence of the crime. There are a lot of different things of the clothing that the suspect was wearing at the time. It could be contraband, such as illegal gambling equipment, illegal weapons, illegal drugs. Fruits of the crime, again, that's the money you received, the stolen property. Other items illegally possessed. Instrumentalities of the crime, such as the weapon used, the credit card swiping machine where you swipe the information off the credit card, printers that are used to print out counterfeit checks, those type things. The persons to be arrested, it can be named in the search warrant, and persons who are unlawfully restrained. So you can get a search warrant to go find somebody that's been basically kidnapped and being held out. Never actually got a search warrant for that, but it's a possibility. In Texas, again, we're back in the Code of Criminal Procedure 18.2, grounds for issuing a search warrant. A search warrant may be issued to search for and seize 1. Property acquired by theft or in any other manner which makes it acquisition a penal offense. 2. Property specially designed or made or adapted for or commonly used in the commission of an offense. 3. Arm and munitions kept or prepared for the purposes of insurrection or a riot. 4. Weapons prohibited by the Penal Code. 5. Gambling devices or equipment, altered gambling equipment or gambling paraphernalia. 6. Obscene material kept or prepared for commercial distribution or exhibition, subject to additional rules set forth by law. 7. A drug, controlled substance, immediate precursor, chemical precursor, other controlled substance property, including an apparatus or paraphernalia kept, prepared, or manufactured in violation of the laws of the state. Pretty much the precursors to make drugs for, usually it's methamphetamine that we're seeing a lot of, so the chemicals and the equipment to make it. 8. Any property, the possession of which is prohibited by law. 9. Implements or instruments used in the commission of a crime. 10. Property or items except the personal writings of the accused, constituting evidence of an offense or constituting evidence tending to show that a particular person committed an offense. 11. Persons. Or 12. Contraband subject to forfeiture under Chapter 59 of this code. So those are the things that you can search for on a search warrant under Texas law. An anticipatory search warrant is a search warrant where you're anticipating that an event's going to occur. It's based upon probable cause that evidence relating to a certain crime will be at a specific place in the future. For instance, if you've got, that drugs are going to be delivered to a particular address at a particular time, they're not there at the time you're getting the warrant, but you anticipate that they will be delivered at that time. So if a particular event occurs, then it allows you to use that search warrant immediately. You may not have time to go get a search warrant. So you're kind of anticipating that the evidence will be there at a particular time. There is probable cause to believe that contraband will be found in a specific if a specific triggering event occurs. And it could be that a red car pulls up and a white female with long blonde hair runs up to the door with a knapsack. That could be the triggering event. And you have probable cause because of informants told you that's how the drugs are going to be delivered. There must be probable cause to believe that the triggering condition will in fact occur. So you have to be able to articulate what the triggering factor is and what's going to occur because of that. Most search warrants are going to contain the following: captions and divisions of the issuing courts, particular description of the place or person to be seized. And when we say particular, we don't just mean the address of the house. You're going to include the address. It's a one-story brick home located on the south side of the street with green gutters on the side of the house and the number 1234 on the side of the house, located in this on Mustang Road in the city of Alvin. I mean, that you get very particular about it. You can also include photographs often to enhance your description that are then made a part of the affidavit. Names of persons who gave supporting affidavits. Statements of grounds of issuance of the warrant. That's your probable cause statement. Names, class of the officers to whom the warrant is to be directed. A command to search the person's place named in the property. When the search may be conducted, day or night. We don't have that much in Texas. You can run the search warrant anytime. You just have to use common sense, though. Name of the judicial officer to whom the warrant is to be returned. It's going to be the issuing judge here. And the date of issuance. And of course, you do have to have the signature of the magistrate. And here is an actual search warrant that was issued in Harris County, Texas. Issued to a Houston police officer, actually a narcotics officer, though the investigation was out of California. It involved Dr. Conrad Murray. Many of you may know him. He was the physician for one Michael Jackson, who apparently overprescribed and was held accountable for that in a California court. Well, the California officers couldn't run a search warrant in Texas. They had to have a Houston officer or a Texas peace officer run the search warrant. So the warrant was issued. As you see, it's styled the state of Texas, county of Harris, and it says to the sheriff or any peace officer of Harris County, Texas. So, it's not limited to the officer who signed the affidavit, though it does list the name of the officer, E.G. Chance, a peace officer employed by the Houston Police Department Narcotics Division in the actual search warrant. He is not the one that has to actually run the search warrant. And the description here is very simple because it was a business. It says a search of the business at 6826 West Montgomery Road in Harris County, and search for, seize, and examine all items, including but not limited to billing records, medication orders, transport receipts, billing receipts, medical records, and computerized medical records for implements and instruments used in the commission of a crime, and for property or items constituting evidence of the offense of manslaughter that tend to show that Dr. Conrad Murray committed said criminal offense. And again, the criminal offense was committed in California, not Texas, but the evidence is in Texas, so a Texas peace officer was the one who was actually issued the warrant. What happens when you have a constitutionally defective warrant? Okay, if there are material misrepresentations or omissions, if the law enforcement officer knowingly, intentionally, or with reckless disregard for the truth makes false or material omissions in an affidavit supporting request for a search warrant, the warrant may not be lawfully issued. If the warrant does issue, evidence seized under the warrant may be suppressed by application of the exclusionary rule and procedures known as the Franks hearing. So, if you lie in your affidavit or you make false statements in your affidavit, voids the warrant, and it voids your using any of the evidence that you obtained from that warrant, or any evidence that you obtained from the evidence that you obtained from the warrant. And by that I mean you get a bad warrant, and you search a residence and you find some information that leads you to another location where you find more evidence. Well, you can't use the evidence that you found at the first location, and you can't use the evidence that you found at the second location. That's called the fruits of the poisonous tree. Frank's hearing occurs for evidence seized under the warrant may be suppressed through the exclusionary rule. Again, comes out of a case of Franks versus Delaware from 1978. Allegations of falsity is significant to trigger Frank's hearing. Rather, the defendant must make prima facie showing that the affidavit statement was deliberately false or demonstrated reckless disregard for the truth. Again, the burden of the proof for this is going to be on the defendant. It's going to be a suppression hearing to suppress the evidence that was developed from the warrant. You'll find them more often in drug cases. And the offending material will be severed or stricken from the warrant. So you may nullify parts of the search warrant, but not other parts. And again, this is a deliberate. You have a typographical error that is not going to invalidate the warrant. But if you actually purposely have information in the warrant that's not true, and you know it's not true, then you're going to lose your warrant. Severability of a search warrant allows you to sever out the invalid portions of the warrant from the valid portions. So let's say, for instance, you have enough probable cause in your warrant to allow you to search for, say, a stolen TV, but your warrant has information in it that is not valid to search for drugs in the house. You would be allowed to introduce the stolen TV that you found, but not the drugs that you found. So the remaining parts where the probable cause is satisfied can be used, but not the portion of your warrant that is invalid. A search warrant is directed in Texas to any peace officer. Usually in some states, only the named officer or member of that named officer's class may execute it. But again, like I said, as you saw from the earlier example, in Texas, it's to any peace officer. In that case, it was to the sheriff or any peace officer of Harris County. So whoever is directed to. Normally, the named officer must be personally present at the search. Again, this is not. This is national or general law here, but in Texas, it's they don't have to be. If a warrant is directed to the sheriff, a deputy may execute the warrant, and the sheriff need not be present. There is a narrow set of circumstances in which a search warrant may be executed by a civilian, even outside the presence of a police officer. I'm not aware of any cases like that here in Texas, where they can direct a civilian to conduct the search warrant. However, civilians can accompany the police on search warrants, and often do, particularly where you have lab technicians or civilian crime scene people that are going to do the actual search, but there will be peace officers present who are, or who are serving the search warrant. They're not necessarily the ones that are actually doing this. Back to the Texas Code of Criminal Procedures, 1806 talks about the execution of warrants. It says, a peace officer to whom a search warrant is delivered shall execute it without delay and forthwith return to the proper magistrate. It must be executed within 3 days from the time of issuance, and shall be executed within a shorter period of time if so directed in the warrant by the magistrate. So you have 3 days to serve the warrant, including the day of issue or the day of the actual service. So really it's 5 days. On searching the place ordered to be searched, the officer executing the warrant shall present a copy of the warrant to the owner of the place if he is present. If the owner of the place is not present, but a person who is present is in possession of the place, the officer shall present a copy of the warrant to the person. Before the officer takes property from the place, he shall prepare a written inventory of the property to be taken. He shall legibly endorse his name on the inventory and present a copy of the inventory to the owner or other persons in possession of the property. If neither the owner nor a person in possession of the property is present when the officer executes the warrant, the officer shall leave a copy of the warrant and the inventory at the place. You always want to give a receipt to the guy for the drugs that you're taking from him. You say, here's your receipt for your drugs were taken. Kind of, kind of earmarks that it is their drugs. Time is a very big consideration in conducting a search. Officers must conduct the search within a reasonable time after the warrant has been issued. And again, in Texas, you've got 3 days, and within any time period specified by law or court of rule. You don't want the information to go stale. If you wait too long, then the drugs will be gone, or whatever you're searching for may no longer be there. Generally, warrants must be executed during the day. Nighttime searches should be authorized by the courts. Again, this is in general. Texas, we run search warrants at night quite often. The length of time for the search warrant must be reasonable. The search is over once the specified items are found. So you're going to, if you're searching and your only thing on the search warrant you're looking for is one stolen TV, you walk in, you trip over the TV as you go in, your search is done. But you're going to usually include in the search warrant enough information that you're going to be searching for that stolen TV and other stolen TVs, which would be evidence. So your search isn't over until you complete the search. But if you're going after just one TV, that's it. And you find it and it's done. You generally want to include in your search warrant descriptions of evidence that's very broad, because you can only search for things that are within your search warrant or within plain view. So if you're searching for something that's very small, you can open a whole lot of drawers, and anything that you find in that drawers would be within plain sight because you're lawfully there, and then you could use it for evidence. Say you're searching for a card out of a cell phone. You can search just about anywhere in the house for that. And if you open the drawer and you find some crack cocaine stuffed in the sock drawer, you within your legal right to seize that and can use it for evidence. In Texas, again, the time consideration, the days allowed for warrant to run, the time allowed for execution of a search warrant exclusive of the day of issues and the day of execution is 15 whole days if the warrant is issued solely to search for and seize specimens from a specified person for DNA analysis and comparison, including blood and saliva samples. A person's DNA is not going to go stale, so that kind of makes sense. You don't have to worry about them getting rid of all their DNA. Or 3 whole days if the warrant is issued for the purpose other than the DNA. The magistrate issuing a search warrant under this chapter shall endorse on the search warrant the date and hour of its issuance. So then you know when your time runs out. And again, we're not including the exclusive of the date of issued or the day of the execution. So it's really 5 days, not 3 days. A warrant is issued to search for and seize data on information contained in or on a computer, a disk drive, flash drive, cellular telephone, or other electronic communication or data storage device. The warrant is considered to be executed within the time allowed if the device is seized before the expiration of the time, notwithstanding any other law or data or information contained in it on the device seized or recovered and analyzed after the expiration date. What they're saying here is if you seize a computer on a search warrant, then the search warrant has been executed. You can then send that computer to the lab and have a forensic analysis done on the computer days or weeks later. And it can take actually months because some of the labs are really backed up. So you don't have to get that all done within the 5-day period. You just have to seize the computer, then you can do the analysis, and you're within the time limit under the law. Searching and securing people and places while a search warrant is being issued. Having a search warrant for a particular location does not give officers a right to search all people and property located there. You have a right to do things for your safety. Persons on the premise may not be searched unless the search warrant particularly authorizes it. Property of non-resident persons who are not the target of the warrant may not be seized. Police may detain persons on the property while executing the search warrant for contraband, and officers may frisk any person on the premises who they reasonably believe to be armed and dangerous. So if you're running a search warrant, for instance, the medical office search warrant, and you got all the medical personnel, the nurses, and all at the premises, you don't really have a right to go in there and search them because there's no there's not an issue of officer safety with that. But if you're doing a search warrant at a drug house where people are known to carry weapons, you're within your right to frisk everybody there, because it is reasonable to believe that people in a drug house will be armed and would be considered dangerous. And anything that you find from this as, under a reasonable suspicion, Terry frisk would be usable. Again, if it's a small item, you're going to have to be able to articulate that you know what the item is. If the person there has something in plain view, even though they're not the subject of the search warrant, they got a joint in their hand, that's seizable because you're there within your legal right, and it's all within plain view. Before entering a premises by force, the execution of the warrant, the officer must knock and announce. They have to give their authority and purpose and wait a reasonable period of time, 30 seconds, whatever is considered reasonable. And this is to prevent violence, to protect the privacy of the occupants of the premises, to prevent property damage, and to give the occupants an opportunity to examine the warrant and point out possible mistakes. Violations may result in police civil liability. Now, you can get no-knock warrants ordered by the judge under particular incidences where you do not have to knock, but you have to show the judge the reason that you believe you need this no-knock warrant. And if you knock on the door and you hear the pitter-patter of people and you hear the commode being flushed repeatedly, then you don't have to wait the full 30 seconds. At that point, you can articulate that you believe they're destroying evidence, and you can make forced entry. As I mentioned, the no-knock exception, you have to show that there are exigent circumstances. You can enter a place by ruse or deception. You knock on the door, UPS delivery, Domino's Pizza, whatever, and when they open the door, then you can kind of rush in. But if the police presence and purpose is already known, again, you don't. For instance, you pull up in your raid van and you got people in the front yard and they see you and they turn and run in the house and shut the door real quick. Pretty much they know what you're there for, and you no longer have to knock and announce because your presence is known and you're there. And then if the judge issues a no-knock warrant, you don't have to knock. The executing officer must have reasonable suspicion that knocking and announcing their presence under the particular circumstance would be dangerous or futile, or that would inhibit the effective investigation of the crime, for example, by the suspect destroying evidence. If the facts and circumstances that create the probable cause include the likelihood that knocking and announcing would be dangerous, futile, and would inhibit the effective investigation, these facts should be expressly articulated in the narrative portion of the affidavit that becomes the basis of the warrant. So you've got to put it in there for the judge to see, for him to issue the no-knock. The affidavit or application for the warrant shall request entry without knocking or announcing, and the warrant should show on its face whether the magistrate approved such entry at the time the warrant was issued. So you just can't do it blanketly. You've got to have the judge's permission. Again, unless you're you knock on the door and you hear them repeatedly flushing the commode, because that's in exigent circumstances then. A sneak and peek warrant, and I've never seen one of these done in the state of Texas, but talking to a tobacco investigator out of Canada, said they used to do them all the time. I thought it was rather interesting. They would sneak in, they would actually bug the houses and sneak out on these sneak and peek warrants. Of course, the laws in Canada are a little bit different than Texas. A sneak and peek is a covert entry warrant that authorizes the officers to enter an unoccupied premises and search for specific evidence, and then leave without seizing the evidence or leaving behind any evidence that they were there. They find, and without leaving a trace, their entry. The items may be seized if it is reasonably necessary, and that's called a sneak and steal, where you kind of sneak in and take the evidence out. Again, these I've never heard of anything like this being issued in Texas under Texas law. I can't say about federal law, but I've never seen one. Now, what could justify a covert search? The officer needs to determine whether certain evidence is on the target premises, or the officer reasonably believes that the suspects would disrupt the investigation by destroying the evidence threatening or killing witnesses, or fleeing if they knew the search had occurred. Now, of course, if you're going to do a sneak and peek, you're either going to be photographing, or, as I said in the case in Canada, they were installing bugging equipment. The scope of a search is very important. Search under the authority of a search warrant may extend to the entire premises described in the search warrant, but only those part of the present premise where the items to be seized might be concealed. The search must be conducted in a manner to avoid unnecessary damage to the property or objects, and the items not named in the warrant may be seized if all elements of plain view doctrine are satisfied. So that's why I say it's important in your search warrants to include any items, the smallest item that you can think of that would constitute evidence that you have probable cause to believe exist. Because if you're searching for a car, you're not going to be able to open up somebody's dresser drawer to look for it. But if you're searching for a matchbook, you can search just about anywhere in the house, and anything you seize at that, or anything you find from this search, would be considered in plain view, because you have a lawful right to open that drawer to look for the matchbook. So if you open the drawer, look for the matchbook, find crack cocaine, then you can seize it and you can use it as evidence. After the search warrant is executed, the officer must leave the search premise a copy of the warrant. You give it to the individual who's being searched, or leave it on the couch if no one's there, or you give it to an occupant of the residence, and a receipt, much like it was in the Texas law. The officer must return the warrant along with the written inventory to the proper judge designated in the warrant, and you just sign off in front of the judge of every. In the case in Harris County, we'll go back to the example. We'll see what they found. It says the undersigned affidavit, and it's signed by the officer who the warrant was issued to, being a peace officer in the laws of the state of Texas, and being duly sworn to oath, certifies the foregoing warrant came to hand on the 20th day of July 2009, and that it was executed on the 22nd day of July 2009 by making the search directed therein pursuant to therefore seizing the following evidence. And they still got a Rolodex, they got pamphlets on Sleep Center, they got Yahoo email from Stacy Howell, they had fax cover sheets, biographical information on the doctor, public storage receipts, rental agreement, move-in receipts, more Rolodex cards, business cards, a photocopy of a picture of the doctor, a Cricket phone receipt, a letter, forensics image of the business computer, where they actually, what you do is you copy the entire hard drive and then do a forensic analysis later on. And then they got a vial of phenytoin, whatever drug that is, and clozapine, whatever drug that is, probably the drugs that Michael Jackson OD'd on. And then the officer signed it in front of the judge. Well, that concludes Chapter 4. Next week, we're going to be looking at Chapter 5, Searches for Electronically Stored Information. Remember, your test is this week. Everybody do really good on it, and you'll watch the next slide for maybe some help on your quiz.